Warm greetings, everyone. This is again Sandeep.C, Convener for Project Complete Lawyer. We will start the session right now. So I welcome everyone, all the participants, all the student members of Project Complete Lawyer and members of Law and Justice Research Foundation and other advocates and legal luminaries and members of the public who have joined this session today. For those who may not be knowing, Project Complete Lawyer is a project. The idea behind which is to reduce the incubation time that is required for a successful law graduate, as a law graduate to become a successful lawyer, into 2 years. So it is a lofty goal for that many of you may assume that it is a lofty goal because conventionally it takes a reasonable time for a law graduate to flourish within the legal profession. More than 2 years or more than 5 years, it is uncertain. And Project Complete Lawyer, through a systematic approach, wants to reduce this uncertainty and to promote the confidence of the law graduates to join the profession and not to abandon it. So towards this goal, we have organized many clinical exercises through which we attempt to introduce the law in its animated form. And for this purpose, we look into many institutions created under the law, especially the High Court, the Supreme Court, and many clinical exercises and academic sessions have been hosted since 2021, since when Project Complete Lawyer was started. This Project Complete Lawyer is organized by two NGOs. One is Cochin Institute of International Arbitration, and the other one is Law and Justice Research Foundation. Both these NGOs are based in Kerala. And today we are having another academic session that is Services under the State, Law and Practice. And today's resource person is Advocate MR HARIRAJ. He's an advocate at Kerala High Court, practicing in Kerala High Court since 1999. He is also practicing in other tribunals, especially consumer forums and trial courts, both civil and criminal side. He specializes in service law, which is a law relating to recruitment and service conditions of government and quasi-government employees. He's also had been serving in the past as the standing counsel for Cochin University of Science and Technology, Sri Chitra Tribunal Institute of Tribunal Institute for Medical Science and Technology, Trivandrum. And he has also served as a special prosecutor for Enforcement Directorate under the Prevention of Money Laundering Act. So he's a person with ample experience and wisdom with regard to service laws, and he's here to enlighten the final year law students who are members of Project Complete Lawyer with regard to service law, which has not been a major focus, unfortunately, in their curriculum, which is in many circumstances outdated. So for their benefit and for the benefit of other audience from outside, the session has been hosted. I welcome you, HARIRAJ sir, to the session. I also want to welcome all the participants, all the members from outside. I also welcome Advocate Johnson Gomez sir, who is the chairperson for Project Complete Lawyer. Without any delay, let us go into the session. HARIRAJ sir, the session, the podium belongs to you.
Thank you, Sandeep. I would request one thing from you. When it is 45 minutes, please notify me. I have a bad habit of the time when I start speaking about law.
By 40 minutes, when 5 minutes is remaining, I will let you know, sir.
Please, thank you.
Yes.
One quaint thing I notice is the attempt Johnson Gomez sir is making is to reduce the incubation period to 2 years. That's what Sandeep said. For the last 20 years, 23 years, I am still not out of my incubation period. The metamorphosis as a lawyer never stops, is what I usually feel. But still, probably the intention is to see that exposure to maximum areas of law is there. In that extent, probably this is one area which I am sufficiently exposed to, is what I consider myself. The subject that I have chosen for the day is too wide, honestly. So wide that it is not possible to exhaustively comment on this. I would therefore, at best, give you a very generic idea, a very where to look for this law, and that alone mentioned today. Because I can, at best, what I can do is to make you enter this maze called service law. Getting out of the maze is totally on yourself. You will have to find your way out, because explaining that may not be possible within a 45-minute session. Where to enter, how to get entangled, that much I can definitely point out to you. As any law, according to me, any area of law, service law, if you are intending to have an idea about this particular branch of law, you should certainly look at the history of this particular section of law. That's true with everything. Sandeep was again pointing out that this particular area of law do not find place in our curriculum as far as the law colleges are concerned, and he is correct. But a huge part of service law is administrative law, which certainly forms part of your curriculum. Administrative law, in its specific application to services under the state, that is what we usually refer to as service law. So it is a hyper specialized area within administrative and constitutional law. And for any law, you have to understand the history of that particular section, that particular law, that particular branch of law. Civil service or service under the government is nothing new. Probably it is as old as state itself. Whenever there was governance, there were officers who probably had delegated power from the royalty, from the prerogatives, who exercised them as against citizens. And to control them, administrative law was formed. And the very same principles apply when the prerogative power is used to hire, fire, and sustain these officers of the state. And that is where service law steps in. As far as India is concerned, we always had services under the crown. We had a lot of crowns for that matter. India was divided, as you know, into a lot of nation states, which were governed by different kings. They all had their own civil service. Probably the Mughals, the Rajput, everybody had their own systems of civil service. But usually it is considered that an organized civil service entered the Indian realm for the first time with the British rule. And that too, it is usually considered that that happened with the Government of India Act of 1858. Government of India Act of 1858 essentially did this. It took away the power from the East India Company and vested it with the crown. That's what 1858 Act does. And when it did so, it also contemplated for an Indian civil service, which was totally under the control of the Secretary for State of Indian Affairs. And in 1861, we had our first Indian Civil Service Act. That continued till 1915 Government of India Act. In 1915 Government of India Act, we first see the entrance of the doctrine of pleasure. I will refer to doctrine of pleasure a little later. 1915 Act said that every government servant in India or every servant under the crown in India will hold office during the pleasure of the crown. The doctrine of pleasure was a doctrine which was already there in common law. It found statutory affirmation in 1915 Act. It finds repetition in 1919 Act. In 1915 and 1919 Act, you will also find certain protections, certain privileges are also conferred on the civil servants. And it is under the 1919 Act that we first find service rules that are being formulated by the executive government. And from then, it was a proliferation of rules. Today, if we look around, we will find each service has its own rule. Every single lawyer who do not usually deal with the area of service law, the biggest challenge they usually face is finding where the rule for this particular service is. That's a challenge we usually face. I get a lot of references from my friends. I'm having this particular case from this particular service. I don't know where to look for the rule. Where is the rule for the transfer? Where is the rule for the promotion? Where is the rule for the confidential reports? For every single thing, there is a rule or an instruction, and accessing it has become a very big challenge. That is basically what most of the lawyers face. You will find that the principles of doctrine of pleasure, the tenure, the principles of protection to government servants, all that find reaffirmations in 1935 Government of India Act, which practically was copied into our constitution in 1950. 1950, when we framed our constitution, we included the doctrine of pleasure. Mind you, we were shifting from a monarchy which was under the crown to a democratic setup under the constitution. But we still retained the doctrine of pleasure. But we also retained the principles based on which protections were granted to government servants. Importance of a free, independent, and strong civil service for the purpose of developing the nation was understood by the constitution makers. They were well aware about that and they were conscious about it, but still they retained the principle of doctrine of pleasure. But you will find a great change in the doctrine of pleasure included in the Constitution of India and the doctrine of pleasure that we usually understand under common law. If you are to make a reading about doctrine of pleasure under common law and doctrine of pleasure under the Indian Constitution, there is a lot of difference. And that, according to me, should be the starting point for understanding service law in India. I have a presentation. I'm not very certain about my internet connection, so I'm not going to show the presentation. I will probably share it with Johnson sir and he can later share it with you. You will find that the doctrine of pleasure is enunciated in Article 310 of the Constitution. That is where I would request you to start reading service law. Article 310. Article 310 says, every government servant will hold office during pleasure of the President of India, or as the case may be, the governor of the state. But then it also says that this is subject to the provisions of the Constitution. And that is the key difference that is there between the doctrine of pleasure in the common law and doctrine of pleasure in the Indian Constitution. You will find there are a lot of restrictions and limitations on this particular doctrine. It is not a principle of hire and fire. It is a principle which is governed and tempered by all principles of administrative law, because the moment you bring in constitution, you bring in the legage of Article 14 and 15 and 16, and you will bring in the legage of Article 21, and more specifically, you will bring in the legages under Article 309, which provide for legislations by the parliament or the legislative houses of the state. When it comes to the state, the services under the state governments, the legislative assemblies of the state can make legislations. The service conditions, the method of appointment, the way they can be thrown out, everything will be governed by the legislations made by the parliament or the state legislatures, as the case may be. And in the absence of any provision in a legislation made by the parliament or the state legislation, it would be governed by the rules made by the president or the governor. And that is where we get this Article 309 rules. We usually refer to it as the rules framed under the proviso to Article 309. Though there is a provision for a legislation, we have very few legislations from the democratic process which govern the field of service law. Even if we have one, most of them leave the niceties to be worked out through rules and instructions. So whenever you look at any particular aspect in service law, the first question you will ask is whether there is a statute made by the state legislature or the central government. And then if there is no act or rules, no act, what are the rules made under the proviso to Article 309? And if there is an act, if the act empowers promulgation of the rules, are there rules made under the act itself? For example, in Kerala, I don't know how many of you are from Kerala and how many of you are from outside. In Kerala, we have the Kerala Public Services Act. But Kerala Public Services Act is probably the shortest act from the state legislature of Kerala, has about 4 sections. It essentially says that rules can be made by the state government for the purpose of governing the service matters. And as far as central government is concerned, of course, we have the All India Service Act, but that also leaves it largely to the central government to make rules. Though there are legislations by the parliament and the state legislatures, we find that most of it only refers back the power to the executive government, and the executive government makes rules. So we have a lot of rules that are made under the proviso to 309 or under the statutes that are made under Article 3091. And the doctrine of pleasure under Article 310 naturally becomes subject to these rules. So whenever you are looking at determination of any service conditions of a government servant, you will look for the rules. We'll come back to the rules a little later. Is my screen visible now?
Yes, sir.
Okay. Is the presentation visible now?
No. Yes.
Okay.
Yes.
Yes, sir.
Thank you for that. So we have the doctrine of pleasure under 310. Then we have the 309 Act and rules. That is what we now covered. Then there are protections to these government servants, which is given under 311. The protections to government servants essentially says a government servant cannot be terminated from service, removed from service, or dismissed from service by an authority who is lower than the authority who appointed it. So it provides for a jurisdictional clause. Who can do the sending out of a government servant? And then it continues to say, if you are going to dismiss or remove a person from service, that exercise can be done by way of penalty only if there is proved misconduct after giving opportunity to it. So Article 311 essentially reads in all the provisions of natural justice as also principles of fair play into punishment of government servants. So this protection is given to them. But then there are exceptions when a person is convicted under a criminal proceedings, or if there is impracticability of conduct of inquiry, or if national security is going to be impinged by virtue of conducting the inquiry can be dispensed with. Of course, we are now in an era where, again, national security is in limelight as far as consideration of this aspect is concerned, whether natural justice can stand excluded by mere statement of national security, etc., is a point that is still at large according to me, which is finding a lot of dilution from the Supreme Court. Anyway, we will not enter into that area for now, because I think otherwise I will not be able to complete what is entrusted with me. Then we also have constitutional provisions which say about public service commissions. Public service commissions are a method by which an independent organization is entrusted with recruitment, as also a consultative missionary which is independent of the government is put in place as far as most of the service conditions are concerned. Again, a very large area. I will not enter into it fully, but do go through these three articles, Article 309, 311 and 315. You will find a beautiful exposition of this particular area under Article 311 and the doctrine of pleasure. I would suggest two decisions. One is Tulsiram Patel and the other is Parshottam Lal Dhingra. If you are not reading any other judgment in service law, please do read these two decisions. 1985, AR 1985 Supreme Court 1416, that is Tulsiram Patel, and Parshottam Lal Dhingra is AR 1958 Supreme Court, page 36. These two decisions, if you read, you have a fair idea about this 311 aspect, as also the principle of doctrine of pleasure. So these two are there. Then we of course have the equality clause. You will find India is one country where a fundamental right is attributed for the purpose of engagement or employment under the state. Equality of opportunity for employment under the state is guaranteed under Article 14. We used to understand originally the reservation granted to the scheduled caste, scheduled tribe, also other weaker sections of society as an exception to Article 16. But later it has been held that Article 16(4) is not an exception, but in fact a demonstrable reiteration of Article 16 itself. Again, a huge area of precedential pressure is there on this particular aspect of service law. What reservation is, to what extent reservations can be made, how reservation is to be understood. If reservation is granted, what the consequence would be. All this find exposition and re-exposition, reconsiderations, overrulings. Probably one area of law which has the maximum number of pages in our law reports is reservation. So again, I will not enter into the niceties of that particular aspect, but I just refer you to the decisions which would be there. Of course, any one decision will never satisfy your search for understanding reservation. Probably we can discuss it after the class. Then there are other sources of law. As I said, we have the acts, the Public Services Act by different states. We have the All India Services Act by the central government. Most of the time, these particular acts, which are legislations by the parliament or by the state legislature, are silent regarding the niceties of service conditions. If you are looking, if you're having a person who comes to you and says, I am transferred from such and such place to such and such place, I want to challenge the transfer. Or if you have a person who comes and says, my junior is given a promotion, I am not given a promotion, I want to get the promotion over him, I am not being considered for a particular deputation, my seniority is fixed wrongly or my pay is fixed wrongly, you will not find an answer to these in the acts. You will have to look at the rules. Again, rules, as I told you, there is a huge proliferation of rules, multiplicity of rules, very, very difficult to find out the rules. But I can only probably give you a very broad guideline. You will have rules of the central government and the state government. So probably the first question you ask the person is, under which government are you working? Which department are you working? Are you coming under the central government? Are you coming under the state government? Are you coming under an autonomous body like the universities? Are you coming under the defense, or are you coming under the civil services? We have the defense services and the civil services under the central government. Again, there is difference. And then probably start looking for which is the acts and rules which are applicable to them. There will be rules which are usually called classification, control and appeal rules. That rules will contain all the paraphernalia regarding how a disciplinary proceeding is conducted, how the how this service is divided into different groups. You will probably come across words like Group B, Group A, Group C, etc. How that classification happens, those things will come under the CCA rules, as they are called. You have the Kerala Civil Service Classification Control and Appeal Rules. You have the Central Civil Service Classification Control and Appeal Rules. Most of the time, every service will have one or other classification, control, and appeal rules associated with it. That is a good place to start with if you are looking for a solution as far as two things. One, disciplinary proceedings. Two, remedies under the service rules. Because if you are looking for whether there exists an appeal or whether there exists a review or revision, etc., against a grievance that has come up before you, that you can probably look for the classification, control, and appeal rules. And that will provide for all the statutory remedies under the particular service. Then there would be the conduct rules. The conduct rules essentially tells how the government servant should behave, how he is supposed to conduct himself, what all are the limitations on his activities. There are a lot of fundamental rights which are not very easily available to government servants, as to say. It was once said that you may have fundamental right to do this and that, but you don't have a fundamental right to be a policeman. So if you are not in tune with the conduct rules, probably you find yourself in difficulty. So conduct rules will tell you basically if there is a misconduct, and if there is a misconduct, to what extent that misconduct is considered, etc. There would be general rules. The general rules, what I am referring to as general rules, are the rules which would govern the seniority, the transfers, the postings, the pay fixations, the pensions. There would be pension rules specifically which govern pensions. There may be rules which govern the retirement benefits. There may be rules which govern the leave. All those which are generally applicable to all services would be there. You will have different rules under the central government and the state government again. So again, to exemplify, I can only refer to the Kerala state and the central government. The Kerala state government has the Kerala service rules. The Kerala service rules contain all the provisions relating to pay fixation and such other matters. The PADA, all those things comes under the KSR. If you are looking for seniority, reservation, and such other things, you will have to look at the Kerala state and subordinate service rules, which is again another general rule. The part 1 and 2 of Kerala state and civil subordinate service rules govern the general rules in state of Kerala. And then there are special rules. Special rules is a word which is usually used in the parlance of Kerala government, Kerala service. I have not seen that kind of a word being used very widely outside Kerala. Outside Kerala, it is usually called the recruitment rules. That is, each service will have different set of recruitment rules. Each service will demand a particular qualification, a particular method of appointment, a particular kind of classification, a particular kind of selection committee. All these things which would be necessary for the selection and appointment to the government service, particular government service, would be governed under the special rules. Why it is called the special rules? It is usually special for each cadre. That is, if you are having junior engineers of the central PWD, they alone will have a special rule or a recruitment rule. And if you are having the sub-inspectors in the Kerala state service, that cannot be of the same rules. They will have different qualifications, different selection criteria, different training criteria, different method of selection, all those things. So these are called the special rules or recruitment rules. So again, if your issue that is coming before you is in relation to selection and appointment, etc., that is the place where you should start searching for. Most of the rules are now available online, but still we have been left high and dry regarding most of the new rules and most of the updated rules. It does not come very easily on the internet. Most of the time, what we who are into this field usually depend upon is either the client himself or probably the Access to Right to Information Act to find out what exactly is the present rule. Of course, rules have to be published in the Gazette, but even Gazette is not an easily accessible thing for us these days. Then there are instructions. That is where the trouble actually starts, because there are a lot of areas on which the statutory rules or the rules under the 309 would be totally silent. For example, as far as transfer is concerned in central government, as far as reservation is concerned in central government, you don't have any rule. There is no statutory rule, nor is there any rule under 309. They are all governed by Government of India instructions. The government keeps on issuing instructions, circulars. As far as Kerala government is concerned, they are known as the GOs, the government orders. These aspects would govern how the service conditions are fixed, how the aspect would be governed. Total silence would be there as far as this is concerned in the rules. There would not be probably a reference at all. And you will have to go for the instructions to find out what exactly is the... and then even bigger trouble is that there are precedents. Most of the time we have precedents which have no reference to the statutory rules or instructions. Sometimes our courts come up with the quaint argument that this is settled principle in service law, etc. We don't know from where that comes, but and they come up with a totally new thing. And usually we have to follow that because it is the court which says that, till that is overruled, that is. So there is a huge area of precedents. Most of the time, you can be rest assured, most of the time there would be conflicting views on the same point. If you are very close and very careful, you will be easily finding precedents on both sides. Of course, this is an aspect relating to administrative law, judicial review of administrative action. How do you go about it? You look at whether there is a jurisdictional error. Whenever there is an action, that action usually has to be done by the person having jurisdiction to take the action. So as I said, under Article 311, it is provided that a person should not be terminated from service by a person who is below the rank of the authority who appointed him. So if a person is dismissed from service by an authority who is not his appointing authority or is lower than his appointing authority, then there is a jurisdictional error. Every administrative action, the first test is whether the person who issued the order has the jurisdiction, and if so, from what statute, whether he has complied with all the necessary paraphernalia, necessary preconditions statutorily imposed for exercise of the jurisdiction. So jurisdiction is the first point of test for any administrative action to be tested. Then there is procedural impropriety. Does the statute itself provide for a procedure? If the statute is totally silent, very recent decision of the Kerala High Court would say that when the total silence is there relating to procedure, natural justice will have to be read into the statute. That particular principle will find reaffirmation in many Supreme Court rulings earlier also. I can immediately remember the name. A lot of decisions are there which say that if it is, even if the statute does not provide for principles of natural justice, it will have to be read into it. There was one decision, I forgot the name of the decision, I will try to find out and again share it with you. There was one decision where the statute provided that a particular person found to be irregularly appointed can be terminated from service without notice. And a person was found to be irregularly appointed, he was sent out of service without notice. It went all the way to Supreme Court. Supreme Court said, true, if a person is found to be irregularly appointed, he can be sent out of service without notice. But for finding that he is irregularly appointed, you have to issue a notice and conduct an inquiry. Then only you can come to a conclusion that he is irregularly appointed. Once that conclusion is there, then you can terminate him without notice, is what the statute says. So very ingenious methods have been formulated by the courts for reading in the principles of natural justice and procedural propriety into every single aspect of service law. But then there are occasions when our courts fail to appreciate it that way, probably sideline something. They came up with the principle that natural justice need not be complied if there is no prejudice caused, etc. Then there is another decision which would say that very violation of natural justice is prejudice. That is why I said there is no, am I audible?
Yes.
There is no consistency, or you cannot certainly be sure that there is no decision on the other side when you are arguing one particular point, especially when it comes to service law. That is my experience on that. Irrationality and arbitrariness is another aspect which you can use to test the administrative fairness. Proportionality is a principle. Again, each of this can probably form part of a full-fledged class for 1 or 2 hours. So I am not going to elaborate on this. There is the principles of promissory estoppel and legitimate expectation. Please don't misunderstand it as two as part of one. It is 2 different things. But again, that is a huge area where you can rely on for judicially reviewing the administrative actions. And then I will conclude today's presentation with the jurisdictions, the judicial jurisdictions on this aspect. As of now, at least in state of Kerala, most of the service matters come under the Administrative Tribunals Act. We have a state administrative tribunal and a central administrative tribunal. All the central government departments, the central government services, the All India services, the civil services under the Defense Department, all these come under the Administrative Tribunals Act. And therefore, because it is covered under the Administrative Tribunals Act, the jurisdiction lies with the Central Administrative Tribunal. There is one good thing about that. When you look at the Administrative Tribunals Act, you will find the rules made there under provide for a very peculiar kind of jurisdiction. Wherever the person is posted, he can have the jurisdiction at that particular administrative tribunal. So normally there was a huge issue relating to people who are pensioners, etc. If it is a pensioner, wherever the pensioner is residing, he will have jurisdiction at that place. So Administrative Tribunals Act to that extent was a beneficial and advantageous development on Article 226, because Article 226 very recently has started spreading into that area, but earlier it was considered that it is not possible to have jurisdiction merely based on the residence of the petitioner. And you have the Armed Forces Tribunals, which are coming under the Armed Forces Tribunals Act, which govern the service matters in respect of uniformed officers of the Army, Navy, and Air Force. Then there are a lot of special tribunals under various statutes. Your university acts contain special tribunals. There are special tribunals in respect of cooperative societies. A lot of special tribunals are there. Those also confer special jurisdictions, most of the time in exclusion of civil courts. So earlier, Section 9 CPC used to be available. But after the promulgation or most of the issues being tribunalized, most of the areas being tribunalized, the power of the civil court under Section 9 has dwindled substantially. But then, of course, there is Article 226 of the Constitution of India. Why? Because, as I earlier pointed out, we have the doctrine of pleasure, and then we have constitutional rights and protections guaranteed under the Constitution. Most of the time, anything which oversteps Article 311 or Article 309 would also overstep Article 14 and 16. So always there is a question of violation of fundamental right. The power under Article 226 of the Constitution of India was always available. But again, if it is a matter which is coming under Administrative Tribunals Act, because there exists an alternate remedy, you would not find the High Court entertaining your Article 226 petition. Article 226 petition is still maintainable against the order of an administrative tribunal. Both the Central Administrative Tribunal and the State Administrative Tribunal, as also the special tribunals under the statutes. Plainly enough, recently the Supreme Court has held that the Armed Forces Tribunal does not come under Article 227 and 226 of the Constitution of India. That is an issue still at large, probably still under consideration if I am not mistaken. So most of the time you will find 226 and 227 jurisdiction, Articles 226 of the Constitution of India and Article 227 of the Constitution of India, under which the High Court exercises a supervisory jurisdiction over the subordinate tribunals, is available for the purpose of testing their propriety of their order. But again, that does not amount to an appeal. There are a lot of limitations on a judicial review jurisdiction under 226 or 227, unless there is a very glaring apparent error of law or fact on the face of the report. The High Court do not usually interfere. But then there are a lot of ways and ingenious methods by which you can always argue that there exists such a error which is on the face of the record, and persuade the court to get a corrective exercise. This question whether the tribunals are actually under the jurisdiction of judicial review jurisdiction of the high courts was considered by the Supreme Court in L. Chandrakumar versus Union of India. If I am not mistaken, it is 1997 Supreme Court. Yes, 1997 Supreme Court. You will find that the Supreme Court went on to say that the conferment of judicial review jurisdiction on the High Court under 226 itself is a basic structure of the Constitution. And even the constitutional amendments cannot dilute or water down or exclude the jurisdiction of the High Court under 226 of the Constitution. So that much is what I think I can say very generally about service law. If there are areas which can be raised as questions, I think I will certainly try to answer. If I am unable to answer, I am having a galaxy of lot of veteran lawyers, including Johnson Gomez sir, M.R. Rajendran Nair sir, etc., who are capable of answering it. You are certain to have an answer. So please come forward with the questions. I also find Dr. Vijay Kumar here. So we are in good company. Any questions, please do shoot. If I know the answer, I will write. If I don't know, the others will answer.
Thank you very much, sir. It was a wonderful presentation by yourself. Everyone, the floor is open to question and answer session. Any questions you may ask? Before raising the question, kindly introduce yourself. Mention your name and profession. Questions, anyone? Very sure that HARIRAJ sir has gone through the hyper specialized service law, the universe of service law in a very short time. That is insufficient. Unfortunately, the framework of our academic sessions are very limited, but nevertheless, I'm sure that there are questions. Even if it is trivial, kindly ask those questions, and he may elaborate on what he may not be able to express on the subject. Anyone is well. No matter how trivial.
Actually, yesterday we had a session on Hari Varunadinte മുന്നോടിയായിട്ട് we had gone through this 308, 309, Doctrine of Pleasure, and Public Service Commission, Administrative Tribunal, Constitution of Administrative Tribunal, and things like that. I think that most of the students could easily connect with what you have. And some sources of administrative law sources ne kurichittu paranju. Administrative law sources rules ne kurichittu paranju. Ee rules ellam 309 അനുസരിച്ച് ഉണ്ടാക്കപ്പെടുന്ന rules തന്നെയല്ലേ, including what we call special rules for a particular cadre. ഇതെല്ലാം 309 അനുസരിച്ച് ഉണ്ടാക്കുന്നതല്ലേ? Can you elaborate on the procedure or how it is being formulated?
So 309 essentially says that the parliament or the state legislature can make an act, and in the absence of an act, the president or the governor can make rules. This is the structure. So most of the time when the statute is made, including All India Service Act or Kerala Service Public Services Act, all these acts also confer the power to formulate the rule on the executive government itself. There had been occasions where the Supreme Court considered whether a rule made under the proviso to Article 309 is in any way superior to a rule which was framed under the statutes. For example, if I remember it right, it was in Karnataka, where they had an act constituting the fire service. And under that fire service, the act constituting the fire service, there was a provision enabling a rule-making provision also. Rules were formulated, which happened to be inconsistent with the general rule formulated under 309 proviso. The Supreme Court said that the special rule will prevail. Because on the principle that a special rule will prevail over a general rule. We have that Latin maxim, generalius non derogant specialibus, something like that. That principle applies. So if you are having a particular rule made for a particular cadre or particular service, that will prevail in respect of that service rather than the general rule, is the normal understanding. Unless the special rule is in any manner found to be violative of 14 or 16. But then that is a totally different question. It's not on the question as to the source of the law, but rather the nature of the
law. Sir, I think one participant has raised a hand. I believe it is Janaki. Janaki, you can ask the question.
Yes, was it the Basudev case you were referring? For regular appointment?
Okay, the question where the question of natural justice was written to the statute, if I remember it. Are you referring to that?
No, sir. For regular appointment, you told that you don't remember a case. So I just Googled
you don't think it is Basudev? Your name is Janaki. Okay, Janaki, I don't think it is Basudev's case I was referring to. I will find the citation and give it to you.
Because, yes, sir. Thank you.
It just fits my mind. I'll certainly find out the citation and send it down to you. But
yes,
it is not Basudev's case. Of course, there. Subsequent to that, we are having the decision in Umadevi versus State of Karnataka versus Umadevi. Umadevi's case, which has practically closed the question of irregular and illegal appointments, which says that if your appointment is found to be without a procedure of law, which is in compliance with Article 16, you don't get any right whatsoever. And then there was Dayanand's case, which said that whatever has been even given to you is not even, or rather you are entitled to during the period of service, that also will not be available to you if your original appointment is irregular also. So, of course, not irregular, illegal. Illegality and irregularity is considered to be slightly different as far as service law is concerned. Irregularity is only when there is some technical defect which can be subsequently cured, you can regularize it. But an illegal appointment is there where the appointment itself is made without reference to Article 14. That is, Article 14 says that there will be equality of opportunity, equality before law and equal protection of laws. Article 16 says that there shall be equality of opportunity for all matters relating to service, government service. And if you are having an appointment which is in violation of that, then no benefit flows therefrom, is what the Supreme Court has held subsequently. So, but I was referring to a decision where the question whether the appointment is irregular, etc., can be decided, whether it can be decided without reference to Article 14 as far as natural justice is concerned. But the Supreme Court said no, before deciding that it is irregular, before a negative result is put on the person, you will have to still have a notice and a procedure.
Okay, thank you, sir.
We have time for another question.
I think
Alexei. Yeah, yes, Alexei. Kindly introduce yourself, Alexei, then ask us. Alexei? Alexei, you're still mute.
She is on mute.
Oh, yes.
think she has totally gone out of it.
Oh, okay, okay. She has gone offline. She wanted to ask the question. I'm not sure. Okay. Is there anyone else? Sir, I am Sandeep. I just want to add a question to you. I just want to put forward a question to you. You have very briefly mentioned about the military tribunal in your presentation. So I again, Alexei has joined back. I think after
Am I
Alexei's
audible?
question, I will ask. Yes, Alexei. Yes.
Okay, so I'm Alexi Joy, doing final year LLB at Government Law College, Trishur, and member of PCL too. So whether the Evidence Act can apply against these proceedings, during these proceedings? I mean, the proceeding against government employees?
No. The disciplinary proceedings, as also the tribunals, are not governed by the statutory provisions of Evidence Act. They are exempted, but still there are certain general principles of evidence. You should understand that when it comes to a question of disciplinary proceeding, it is not necessary that there should be proof beyond doubt to find a person guilty. Though it is a penalty that is being imposed, it is not a criminal proceeding. It is at best a quasi-criminal proceeding. So the principles of Evidence Act will not apply, and the weight of evidence that is necessary is also different. You know, it is not necessary to prove the charge beyond doubt. Preponderance of probability is more than sufficient to find a person guilty when it comes to disciplinary proceeding. So the principles, very broad general principles of evidence, like probably like a person who affirms has to prove, etc., would apply, but not every single statutory provision of Evidence Act. No, it doesn't apply.
Thank you, sir.
Okay. So may I ask the question, sir? That is,
Yes,
with
sir.
regard to the military tribunal, that you briefly mentioned in the presentation. I came across this information a long time ago. Whether it has changed or not, I don't know. But nevertheless, I just want to confirm this from your side or from anyone who is present here. Am I audible? I hope I am audible.
Yes, I am getting it slightly broken,
Hello?
but doesn't matter. I'm getting it a little broken.
Okay. Sure. So my question is, with regard to military tribunal, I have in the past, with regard to the military tribunals in the past, what I have understood is that the tribunal is manned by, there is no division between judiciary and the executive when it comes to judicial remedies for military officers. That is what I briefly understood. Whether that situation has changed or not. Whether it has improved or not. What I have understood is the higher office.
I did not follow the question very specifically.
The
division between the executive and the judicial.
That is a separation of judiciary and
division between executive and
judicial. Yes. Is it absent in the military tribunal?
Okay. No, basically military, as far as military is concerned, the question of discipline is usually considered even by courts with a larger amount of strictness because it's a uniform service. You see, even in police for that matter, a uniform service is not considered to be on par with the normal civil service. When it comes to the question of discipline, the pressure on the employee is far higher. Not that a civil servant can be indisciplined, but the requirement under the law, as far as a uniformed officer in respect of discipline, is usually considered to be far, far higher, even by the courts. So I have not come across any division between the executive government and judiciary in this aspect. Of course, at every point of time, the executive government has always been unhappy about this system of judicial review most of the time. There are very few officers who would probably understand the requirement and necessity of there being such a check and balance. The others consider this as a unnecessary intervention into their powers for doing what they are supposed to do. But that apart, there is no specific split of opinion. This military tribunal itself contains a administrative member and a judicial member. Every tribunal, the question of tribunalization comes when you are having a tribunal. You have a mix of both judiciary and the executive government. When it comes to the central administrative tribunal, you will have either an IAS officer, an IRS officer, an All India Service officer usually, and a judge, a person who is from the side of the judicial side, either a lawyer or a judge or a justice of the High Court or the Supreme Court. They sit in a division bench. So the idea basically is that the bench will have the judicial temperament from the side of the judicial member, and the administrative, being alive to the administrative exigencies and being knowledgeable about the administrative procedure from the administrative side. So it is supposed to balance these two. So we have an administrative member and a judicial member. When it comes to the Armed Forces Tribunal, it is usually a officer of the military who is either retired or who has held one of the highest posts in that department, who would be sitting along with a judicial member as a division bench to consider cases. So there is always a balance, at least supposedly to have a balance most of the time. But when it comes to uniformed services, the discipline, the requirement of discipline is far higher. I think one of the oldest cases we have from the High Court of Kerala, which considered was a case where policemen who were deployed to Shabarimala, whether they can be permitted to, or they are supposed to be required to cut their hair, shave, or something like that. And finally, the High Court said, as far as the discipline is concerned, there is no compromise. Shabarimala or anywhere else, police is police, and you have to behave like police. And only at the Sannidhanam, I think they don't wear the shoe. Everywhere else, even the police is supposed to wear the shoe. They are supposed to be in the uniform. I don't know what is the present position, but I have come across one decision to that effect. Even as far as discipline is concerned, they usually put a higher benchmark for the uniformed services. That is always there. Armed forces, as also the police, as also the paramilitary forces, the CRPF, the Assam Rifles, and all that stuff. Everywhere it's considered as a uniform service. You have a special benchmark as far as discipline is concerned.
Understood, sir. Thank you for your reply. So everyone, I hope there are no further questions. If there are any, you can just post it to our email, completelawyer2020@gmail.com. Send it to our email. I will try to collect all the questions if there is any, and forward to Advocate HARIRAJ sir. He will be kind enough to answer them at his convenience. So we have run out of time, and to conclude the session, I invite Aravind, one of the student members of Project Complete Lawyer, to convey the vote of thanks.
Before you go to Aravind, may I also place on record my immense gratitude to this system, especially
yes, sir.
Me and inspiring me to learn this once more. Thank you so much.
Okay, sir. Thank you so much. On behalf of Chalta sir, I will convey his gratitude. Back to Arvind.
Good evening, everyone. First and foremost, I express my deep gratitude to the honorable guest and speaker for today's clinical exercise, Advocate M.R. HARIRAJ sir, for taking out time from his busy schedule to grace the event. Thank you for covering all aspects relating to service under state law and practice within a short span, also educating and enlightening us with your insights on this topic. Indeed, you have beautifully orchestrated the link between constitution and service laws in India. We are also grateful to Johnson sir, chairman of Project Complete Lawyer, for providing great support to this clinical exercise. I also extend my sincere gratitude to SANDEEP.C, convener of Project Complete Lawyer, to organize this clinical exercise. Last but not the least, I take this opportunity to thank all the eminent dignitaries and participants who have joined this session for their presence and contribution to make this clinical exercise a great success. Thank you once again.
Thank you everyone for your time and patience. See you all in another session. Good night.
Thank you, Hari. Thank you.
Thank you, sir.